Good afternoon, everyone, and welcome. My name is Dave Leonard, and I have the great privilege of being the CEO of McCarthy Tétrault, and just thrilled to have you all with us today for our webinar, Cross-Border, a Guide to Doing Business in Canada, Key Topics and Development. So thank you all for being here. We've got over 500 of you, both in Canada and the U.S. Online. And this event actually started out as something to celebrate the launch of our Labour and Employment Group's new cross-border book, Navigating Canadian Employment Law Guidebook. And as we were thinking about it, we were reflecting back on sort of the last 25 months or so that we've all been living with the pandemic. And certainly our Labour and Employment Group has been at the forefront of advising both the firm, but most importantly, all of you, our clients, on the many issues that have arisen, not just labor and employment issues, but many issues that cut across all aspects of how we operate our businesses, how you operate your businesses, whether that's in Canada, in the U.S. or really around the world. And so we thought, we wanted to launch the book, and just a few words about the book. The book is fantastic. You'll all be receiving an electronic version of the book. It uses the U.S. law as a baseline comparator, and it gives you in a very easy to read style, very informative, sort of the top 10 differences you'll find between Canadian labor and employment law and U.S. labor and employment law. And I know many of you have operations both in Canada and the U.S., and sometimes it's challenging to navigate the differences. And so the guidebook is really something that I think you'll find is a great quick resource for U.S. and international lawyers and HR professionals, and even quite frankly, Canadians who are responsible for HR operations in the U.S. and abroad. And so, as I said, each of you will receive a copy of that. But as we were thinking about this session and all of the great work that not only our Labour and Employment Group has done, and really they've been coordinating it, but many of our practice areas across the firm have been assisting and advising businesses. We thought it would be terrific to do something a bit broader than just simply talking about the labor and employment cross-border issues today, but really broaden that out to doing business in Canada and how that cuts across so many areas in our firm. So for our Canadian and our international clients, we designed a discussion that will cover not only labor and employment, current employment law issues, but also a wide range of other topics. And so we have some of our industry leading partners with you today to discuss a number of topics. They'll talk to you about class action lawsuits. They'll talk to you about supply chain, custom and trade issues, privacy, data and cybersecurity. And I know that's on the minds of well, really almost all of us from time to time these days, given the risks and the threats. Mergers and acquisitions, and what we're seeing there, competition law issues, and then finally fintech. And we have, as you all may know, we have one of the leading practices in fintech, and so we've got our folks here to talk to you sort of about most recent developments in that area. So I think it will be a very educational 2 hours. Our firm blogs and has many posts about cross-border issues, doing business in the U.S. And for U.S. folks doing business in Canada and really around the world. So the session is quite ambitious. We've got 2 hours set aside. There are a lot, as I said, a lot of areas that we want to cover, a lot of information we want to impart to you. We think it will be very helpful for you. We hope you'll enjoy it. We're going to try and hit the key developments in these areas, and I have no doubt that it'll prompt some further thinking and discussion on your end. And of course, we would invite you to follow up with any one of our partners that you hear from today if you have questions or want a bit more in-depth discussion about particular issues as they relate to your business and your operations. So Thank you again for taking the time. We know how very busy you are, particularly as we head in Canada into our national holiday on Friday, and then our friends in the U.S. head into their national holiday on Monday. We each have a long weekend coming up, just different days off. So we appreciate you being here with us. So thank you. At the end, there'll be a survey when you finish off. If you just take, I think it's under 30 seconds just to fill out the survey, because we always want to make sure that we're providing you with information that's relevant and doing it in an effective and informative way. So please take a second to do that. And there are CPD credits available, and I think that'll be discussed a bit later on. But with that, I want to introduce you to and turn it over to Tim Lawson. Tim's the head of our labor and employment group at the firm. And Tim is going to be your MC the rest of the way through the show. So enjoy. Thank you again for joining us. And Tim, over to you.
Great, thank you, Dave. Yeah, I'll be your virtual MC for the next 2 hours. Appreciate the introduction, Dave. You hit a lot of the key points about our book. Quite excited about it. And as you said, it's a great overview of labor and employment, and we used the U.S. comparator to help us really highlight, the differences and frankly the stark differences between Canadian labor and employment law in the U.S. And we think it's an easy read. And many of our clients and cross-border work involves U.S. clients, U.S. transactions related to and also international. Of course, we have people on the line today from a variety of European countries as well. So the book is also useful there. Now, let me just take you through a quick stroll of the index to show you kind of the broad areas the book covers. This is in the index, but it just gives you a sense of what we're trying to cover. And these are all, of course, key areas in Canadian labor and employment law that we advise clients on all the time. And often, one or two of them are very, very current at the moment. So we obviously cover the 10 differences between Canadian and U.S. employment law right at the front end of the book. We talk about if you're operating a business, what are the employment law considerations? And then we go through the sort of the phases of hiring, retention of employees, terminations, departing employees, and importantly, a section on remaining union free. And as we see, increased wage pressure and kind of social disruption, there's a lot more organizing activity that's occurring in Canada, which has fairly liberal union organizing laws right across the provinces. And then we talk about Quebec. Quebec has the Civil Code, which is unique, sort of like the state of Louisiana in the U.S. in that sense. So there's unique differences in Quebec that have to be understood if you're operating in that province, which is the second largest populous province in the country. So it's a big market. And then executives, there's always unique issues in Canada around executive compensation, structuring contracts, non-competes, etc. And of course, what's a Canadian book without buying and selling Canadian businesses? So that's the nature of the book, just to give you a sense of what's in there. So read on the long weekend. Fascinating lakeside reading on the beach. Anyway, let's just get into, before I turn over to 6 other incredible partner panelists, I want to cover 4 key topics that will be interest to any company that's doing business in Canada or employs or will employ people in Canada. So if we can go to the next slide. Thank you. We'll cover termination clauses, then we'll cover restrictive covenant clauses. We'll talk about the policy to disconnect. And we'll just touch a little bit on the new French language laws that will have an impact upon your business. So let me talk about termination clauses first. And one of the most important differences between U.S. and Canadian employment law is that, unlike in the U.S., Canada does not have at-will employment, as that concept understood in the U.S. and that has enormous implications in terms of the nature of the relationship and the power that each party, the employee and the employer, have over each other. And there's a certain security, I would say, that employees in Canada have that that doesn't exist in the U.S. However, I would say that in theory, Canada does have at-will employment, in the sense that, with certain exceptions like unionized employees or non-managers in Quebec or the federal sector, employers in Canada, can terminate employees' employment at will for any reason at any time, provided there's no statutory violations such as discrimination or violations of occupational health and safety. But the difference in Canada is that unless the termination is for reasons that amount to just cause in law, which is very serious in Canada, the threshold's high. You have to steal something, you have to have a major conflict of interest, terrible, uncorrected performance, sexual harassment. Those all may amount to cause. If you don't have cause, you're not terminating for cause, then there's a requirement to provide an employee with reasonable notice of termination, which can be given by way of working notice or pay in lieu or a combination. So the question is, how much notice is required? So if you don't have a termination clause in the employment contract, sort of defining and setting out the termination entitlements, then the assessment of the amount of notice you have to give on termination is determined by the common law or by the civil law in Quebec. In other words, the courts establish it for you based on length of service and age and position, et cetera. And this notice could be way beyond what might seem reasonable. And lengths of notice have been sort of inexplicably increasing over the years. Very little explanation as to why. Employment rates have been declining. But we used to always say, look, it's about a month a year is the rule of thumb, a month a year of service. But that rule is no longer a useful one, because what we're seeing is courts awarding notice periods that verge on about a year, about a month and a half per year of service, with the maximum sort of tickling beyond 24 up to 28 and 28, depending on the length of service. So it's not uncommon to see court awards of 18 months, up to 18 months for a 12-month employee. So the response to these increasing notice periods is to place reasonable limits on them through employment contracts. It's difficult in Quebec to uphold an employment termination clause, but elsewhere in the country it is. But these employment contract clauses, which define severance entitlements, are really under assault from courts. And courts are doing gymnastics all the time to try and avoid the results of the limitation clause, because invalidating a clause gives the employee the much higher common law or civil law notice. So it's like insurance. So courts are routinely voiding termination clauses for a variety of reasons. Minor technical violations of employment standards legislation unrelated to the circumstances around the termination, ambiguity. Even the slightest ambiguity now will be construed against the employer and void a clause, and things like lack of consideration depending on when the contract was signed, what was provided, in exchange for the terms. But all this is to say that we say don't give up on termination clauses in contracts in Canada. They still can be drafted and be enforceable, and they're probably the most important clause in any Canadian employment contract. In comparison to the U.S., you don't want to have an employment contract per se. In Canada, you do want to have an employment contract, because if you don't, and you don't define the terms in the contract around termination and other terms, then the courts will decide it for you. But just be wary that a clause that you draft today just may not be enforceable tomorrow because of the way in which the law is evolving. So I wanted to highlight that as sort of issue number one. I want to take you to next issue, which are post-employment restrictive covenants. So like termination clauses in Canada, post-employment restrictive covenants like non-competes and non-solicit clauses are also under heavy attack by courts and indeed some governments. And that's not really surprising, because if you look around internationally, countries like France and Germany, China, some of the states like California and other states in the U.S., Mexico, you'll see countries kind of grappling with the validity, enforceability, and justification, frankly, for non-competition restrictions post-termination and non-solicitation clauses. In Canada, the courts have been eroding their enforceability for years, and our case laws developed such that non-competes are considered to be unlawful restraints of trade. So they're illegal per se, unless the employer can convince a court that they're justifiable. And they're justifiable if you can say to a court that they're very limited, they're industry specific, they're necessary. They talk about restrictions only in respect of competitors and products, and the time limit is narrow. But having said all that, the Ontario government, and this is very important, recently came out with a law which essentially bans all non-competition clauses post-termination. And that's effective, was effective as of October 25th of last year. So any restrictive non-compete clause negotiated and introduced into an employment contract post October 25th of 2021 will be illegal by law, which puts Ontario at the far end of the international spectrum in terms of this issue. And there's only two exceptions to that outright ban. One is the employee has to be a chief executive level employee, or there's been a sale of business and the sale involves a sole proprietorship or a partnership. So this sale of business exemption for those who do transactions in Canada is very narrow. Again, only applies to sole proprietorship sales and partnerships. So it doesn't apply to larger sales. So interesting issue, beware of it. Non-competes are very difficult now to introduce into contracts in Ontario, obviously. Luckily, most other provinces haven't introduced that legislation. So that's non-competes. Let me just quickly talk about the right to disconnect. So in recent years, large influential companies like France, Italy, and Spain, Ireland have introduced so-called right to disconnect legislation, which is designed to regulate when an employee is required to engage in work-related communications after normal working hours, like answering emails or going on video calls, answering text messages, making phone calls, those sort of things. So again, Ontario is the province that looked internationally, and it's the first province following this trend, now requires, as of June 2nd, that all employers with 25 or more employees have a written policy on disconnecting from work. Disconnection defined as engaging in work-related communications like emails, telephone calls, video calls, sending and reviewing messages, and disconnection means to be free of all of that stuff. So the media, if you followed it, in our view, create a lot of confusion about this issue. The media seems to think that this legislation, creates an absolute employee right to disconnect, preventing the employer from contacting employees after hours and allowing employees to refuse to reply to emails or jump on video calls. And that's just not correct under the law. There's no statutory right to disconnect. The law only requires that employers communicate to their employees about what their expectations are about the employee answering calls, dealing with emails, text messages after hours. So just some important things to keep in mind in that regard. If you don't have 25 employees in Ontario, this policy doesn't apply to you. You don't have to count employees outside of Ontario in that count. The disconnection policy has to apply to all level of employees in Ontario. So surprisingly and sort of disappointingly, there's no carve out for management or executives from this policy. Now, you don't have to have the same policy for all employees. You can certainly have separate policies for different levels of employees, different groups of employees, different types of work that they perform, setting out the different expectations around should you not answer calls, emails, etc. after what are considered to be normal work hours, which is kind of a difficult concept when you're talking about managers and above. The only specific requirement under the policy is it must have a date the policy was prepared and the date any changes were made, and the rest is entirely up to you. So what employers are doing generally is they're not creating a right to disconnect. Rather, they're stating that, look, subject to business and operational needs, you should use your discretion, employees, to whether or not you disconnect from work. That would be the general statement, and then there might be, more specific guidance, underneath that. But that's generally what employers are doing. But just remember that employees who are non-exempt from overtime, hours of work rules, those still apply. So if someone is answering emails after hours and they're a non-exempt employee, then you'll still have to pay them overtime. Finally, I just want to touch briefly on the French language requirements imposed by the government of Quebec, effective this month, as of June 1st, for every employer, company rather, that does business in Quebec. These provisions are intended to strengthen the status of the French language in Quebec. That's the goal. And so what does that mean? Well, a couple things, well, many things actually. First of all, as an employer, you now have to communicate in writing with your employees in French, in respect of most written employment documents, like employment contracts, offers of transfers, policies, procedures, training documents, applications for employment. The only exception to the French requirement is if the employee doesn't want to have that information communicated them in French. So they have to individually request another language. Job postings, interesting piece of legislation. From now on in Quebec, job postings have to be done and posted in French and English. It's not surprising, but they have to be posted at the same time and by the same means of transmission, and they must reach the same target audience of comparable size. So for example, if you put a job posting out on monster.ca in English that can reach a million people, let's say, that speak English, there has to be a comparable job posting put on a French website that reaches that same comparable number of potential recipients. So there may be some challenges around that, just because of the discrepancy between the number of people that speak English in this country and the number that speak French. What else? If you post a requirement of knowledge of a language that's other than French, so for example, if you have a position that speaks to English customers, you have to show as an employer in Quebec that you've taken all reasonable steps to not impose that English requirement on the job. And then you also have to go as far as to show that you've restricted as much as possible the number of positions within your company that require a language other than French. So there's a whole bunch of restrictions and limitations around language other than French. It obviously is positive in terms of promoting the French language, but it's a very administrative. There's committees, francization committees that need to be implemented in Quebec. They have to analyze, submit. You have to submit documents to the Quebec government. You need a committee, and you have to address the French language in the workplace. And the fines are significant. So the bottom line on the French language piece, Bill 96, is if you're operating as an employer in Quebec, you really do have to translate your documents now. There's really no room for error on this one. And I'm reminded by our translation department in Quebec that they're ready to help you with that. So that's it for my update. So I will turn it over now to Jennifer Longhurst, and Jennifer will speak to us about M&A and Jennifer is a new addition to our business law group, and very excited she's joined us. She has extensive experience in complex mergers and acquisitions, private and public, all industries, all capital markets, and I'm sure she'll keep us very engaged for the next few minutes. So over to you, Jennifer.
Thank you, Tim, and good afternoon, everyone. Delighted to be here. I'm going to do a little bit of a whirlwind on starting with a bit of an overview on M&A from a comparative perspective, principally focused on Canada versus the U.S. and some core features of M&A in Canada versus U.S. And then I'm going to ambitiously try to hit on about four key developments or trends we're seeing that I think will be relevant to this group. So first, maybe before I dive into the overview, what's going on with M&A today? I'm sure as many of you are experiencing, there has been a bit of a softening in the market. Canada is no different in that respect from the US, and frankly, globally, there's been a softening due to various geopolitical, economic, and other events that we're all seeing and hearing about daily. That being said, M&A is still happening. It's a bit slower moving these days, and in particular, I think a lot of people are grappling with perceived valuation gaps given everything that's going on in the economy and, again, geopolitical events. Certainly in Canada, for example, for some of you, the resource and mining industry, there's still a push for consolidation there, and with commodity prices, there's still lots of opportunity there, and there's several other industries that we're still seeing interest and opportunities in M&A. So with that, what are the main structures? You'll see on this slide here, I've given a bit of a brief overview. Certainly from a private M&A perspective, the main structures in Canada and the US are share sales, asset sales, or another category that we'll call business combinations, and that would be, say, an amalgamation or a plan of arrangement in Canada, or similarly, but not exact same, merger in the US. From a public M&A perspective, slightly different from the US, the most common vehicle for effecting purchase or sale of a public company business in Canada is a plan of arrangement. And a plan of arrangement is a statutory process that is set out in virtually all of the corporate statutes across Canada and at the federal level. But importantly, it's also a court-supervised process. And in those cases, in addition to getting shareholder approval for a transaction, which is typically at a 66 2/3 approval level at a meeting called by the target company for its shareholders, but a court also oversees the process, and it really oversees two aspects in two hearings. One is kind of the logistics or procedural aspects of that transaction, but importantly then ultimately pronounces on the substantive fairness of that transaction. And that's at a final hearing where a court will look at whether the transaction is fair and reasonable. Like all private M&A deals, a plan of arrangement can only be effected in a friendly fashion that is negotiated between a target and a buyer. And ultimately, its real utility is the flexibility it affords. And that flexibility is one, because you can basically, in a plan of arrangement, affect most any type of transaction. So exchanges of securities, importantly, and why one of the many reasons it's so popular, dealing with a whole host of incentive awards like RSUs, PSUs, DSUs, options that may be spread across directors, officers, employees. There's a lot of flexibility there. But also importantly, from a Canada-US perspective, a plan of arrangement, because it's court supervised, also provides an exemption in cases where a purchaser wants to distribute securities. In that case, it's known as a 3A10 exemption in the US, and similar exemptions at the state level. But because it's court supervised, that distribution of securities would be exempt from registration. So hugely helpful. There are other structures to affect public M&A. The only other one I'd touch on is really a takeover bid, which is governed by a whole host of prescribed rules under securities law in Canada. It looks a lot like a U.S. tender offer, but it is quite different. And really the utility there is that's about the only vehicle available for a purchaser who wants to do an unsolicited or hostile acquisition. Quickly touching on directors' duties. Again, directors and officers' duties in Canada are in many ways similar to U.S. duties. So in Canada, we have a fiduciary duty and a duty of care, much like a duty of loyalty in the U.S. What's a bit distinct in the Canadian context, though, is that duty in all circumstances remains a duty to consider whether a transaction is in the best interest of a corporation. And that duty doesn't shift in a change of control context versus in the US, as you'll know, the Revlon duty often shifts that duty to a value maximizing duty. In Canada, it is deciding what's in the best interest of the corporation. And what's really important about that is how stakeholder interests play into that. Value maximizing transactions or the highest value transaction may very well be what's in the best interest of the corporation, but corporations are, and their boards should be considering how a transaction impacts various stakeholders, including, for example, employees, retirees of a target company, pensioners of a target company. And so those things become very important considerations. And I would say with the focus on stakeholder capitalism, which I think you're all hearing about in the media almost daily, considering those broad stakeholder interests, as well as the communities in which you operate, all of those things become very core in deciding whether or not a transaction is in the best interests of a particular company. And if those duties are carried out, the last thing I would focus on is that if the duties are carried out, then directors and officers should be shielded from personal liability and be able to rely on the business judgment rule. However, what this means is process is particularly paramount. And I would say one of the many ways that process can be compromised is, for example, where you may have a CEO or senior management with change of control entitlements or other benefits that they would receive as a result of the sale of their business. And yet those people are the very people negotiating the deal. So process is acutely important, especially in public M&A, which we'll touch on shortly. And so there may be many situations where a special committee and other protections need to be put in place to make sure there's appropriate supervision and appropriate protections put in place to mitigate risks of conflicts of interest. So going to the next slide now, I want to touch on four key trends or developments. The first I already alluded to, and that is the treatment or consideration of stakeholders in any purchase and sale of a business. You hear in the media every day focus on ESG issues. I've already mentioned consideration of stakeholder capitalism, but COVID has also really accelerated a focus on a broad range of stakeholders, including, you know, a host of issues relating to human capital, relating to human rights, relating to social justice issues, relating to diversity. So all of these things are even more important to think about in the context of M&A transactions. For example, one place we've seen this come up for is in merger agreements or transaction agreements, whatever the title is going to be, in both the US and Canada. You'll see, for example, a lot of enhanced reps and warranties and covenants surrounding all of these issues, where buyers are trying to understand not only if there are legal issues there, but also if there are reputational risks or issues there after they've acquired a business. So you will see in merger agreements increasingly now really robust reps around those things, but also specific covenants or reps relating to things like, I've given the example here, a Weinstein clause. And that's a clause that seeks to get assurance that there's been no claims or allegations of sexual harassment, discrimination, other sorts of physical assault, harassment, discrimination. And that's just one of many examples. The second point I want to talk about is change of control provisions and incentive awards. There's a lot of focus on these in any negotiation of a purchase and sale of a business. And for some businesses, it can be quite complex because there can be a whole host of different types of awards. Obviously, tax in many ways rules the world. And so tax will drive in large part the treatment of some of these awards and deals. But there's also, again, a lot more focus around some of the more practical or softer issues relating to these awards. And so, for example, softer issues are, cash flows. How is a target paying out these awards if they're actually getting paid out? But also, how will these awards be perceived? Sometimes you will see in deals these massive payouts to executives and directors in a sale of a business, but in contrast, you may have shareholders receiving a lower premium, or you may have employees otherwise being compromised, losing jobs in a transaction. So again, focusing on the tone, focusing on the perception and optics of how these are treated are very important. And then, of course, there are sometimes in deals what we refer to as collateral benefits, where directors and officers may be getting something different from shareholders. And I flag those because those are issues that will often dictate the need to have a special committee and other special processes and enhanced disclosure in place in a public M&A context because of the risks and conflicts those create. Last 2 points I want to focus on. One is I've referred to here real-time review in public M&A transactions. Just something to be aware of. Certain types of transactions in Canada are immediately reviewed in real time by our securities regulators. And what they'll be particularly focused on will be the process leading up to a deal being approved. How executives and directors are being treated in the deal, what benefits they're getting. And so just be aware, some transactions will be placed under scrutiny, and some transactions, and we've seen many transactions, get delayed or potentially even blocked because those protections haven't properly been put in place and a proper process hasn't been followed. And the last point I will flag for you is M&A activism. You probably hear about it. It's happening almost daily, and there is virtually no deal in Canada, the U.S., and almost globally that is immune from M&A activism. And that would be activism from shareholders unhappy with a deal, but it's also activism from more non-traditional sources like lobby groups, like unions, like employees that are unhappy about their treatment in a deal. The upshot is, with M&A activism, both targets and buyers need to be aware of it and need to plan and anticipate for activism as part of any deal. And so that's it for me. Thank you very much for having me. Tim, back over to you.
Thanks a lot, Jennifer. Every time I talk to Jennifer, I feel like I'm watching the Netflix miniseries Succession. It's just fascinating. I'm going to turn it over to Anna Badur. Anna is a partner in our financial services group. She's going to talk about fintech activity in Canada. She co-leads the fintech group and is a certified anti-money laundering specialist. So focusing on things like blockchains and cryptocurrency. So I'll just turn it over to you, Anna. Thank you.
Great. Thank you, and glad to be here today. So we'll be switching gears a little bit and really looking at an industry specifically. We're a very industry-focused law firm, and so certainly appropriate in that respect. So looking at fintech activity in Canada, if we can go to the next slide, just some recent trends in terms of what's happening in Canada. So we've got a pretty deep and broad fintech industry in Canada. It includes some very large players on the payments side, a number of which are publicly listed and well known. A lot of activity in the cryptocurrency space. In particular, there were a number of cryptocurrency funds that were approved in Canada prior to being approved in the U.S., where they're still waiting for securities regulator approval. We've got some trading platforms, both domestics and foreign players looking at Canada. We've got some cryptocurrency miners in Canada due to, in part, the lower cost of energy here. So certainly quite a bit going on the cryptocurrency side. A lot going on the lending side as well, with buy now, pay later becoming more and more available as a way to essentially purchase items on credit. So almost a mix of payments and lending. We've been seeing what's known as neobanks or challenger banks start to establish in Canada. That's really the idea of having an entity that's not a bank, but provides a lot of the same similar services and kind of a breadth of services. So certainly a number of those have been starting to get established. And then concurrently with that, we're seeing a lot going on in payments in Canada, where there's a modernization of the payment infrastructure happening, as well as our federal government working on what's known as open banking, essentially allowing broader access to financial information by third parties. So all of this is happening. We are starting to see as well some unicorns in the fintech industry in Canada emerge, a lot of them either the neobank or the cryptocurrency space. So certainly a robust industry on the Canadian side. If we move to the next slide, we won't spend too long on this. This is just one of the fintech maps that's available to show you essentially, the breadth and depth of what we're seeing in Canada. So you can see there's a lot of different segments and a lot of different companies that have been essentially launching and growing in this space. So we'll turn to the next slide and talk through fintech regulation in Canada. And in part, why that's helpful is that when we're talking about fintech regulation in Canada, we're essentially giving a very quick overview of how financial services are regulated in Canada. And that's a helpful thing to understand. In part, every jurisdiction regulates financial services a bit differently. And so there are certainly some commonalities and some quirks to how the financial services sector is regulated in Canada. So at the high level, there's both federal and provincial regulation. So certainly that distinguishes it from some jurisdictions like the UK, for example, but common to the US. And then we've got a mix of both what's known as entity-based regulation and activity-based regulation. So entity-based regulation applies to certain types of entities. So banks would be a well-known example of that. There's regulation that applies to banks no matter what they do. And activity-based regulation applies depending on what type of activity an entity may do. So to the extent an entity engages in lending, for example, there may be some registration or licensing requirements in certain provinces. For payments, there's what's known as money services business, which is a type of entity that is regulated under our anti-money laundering legislation. There's a new Retail Payment Activities Act that's been launched, not yet live, but will essentially result in the regulation of payment service providers in Canada by the Bank of Canada. And then on the security side, there's a breadth of what's covered. It captures a lot of cryptocurrency business models, as well as what's known as wealth tech. So everything from robo-advisors to dealers offering novel products. And then insurance as well, both federally and provincially regulated, and captures a number of activities in this space as well. We turn to the next slide. In terms of the licensing process, it really varies significantly depending on the type of entity or activity. So those entities that are falling under the entity-based regulation. So banks, credit union, trust companies, some insurance companies. Certainly that licensing process tends to be very involved, sometimes multi-year, and really requiring dedicated efforts and resources. In contrast, some of the licensing, for example, money services business registration, quite straightforward. Most lending registrations are fairly straightforward as well. Securities does tend to be much more involved, and maybe either an exemption process or a licensing process, typically multi-month as well. And then insurance also tends to be on the longer side in terms of the licensing process. Turning to the next slide, in terms of what we're seeing on supervision and enforcement, we are seeing a broad range in terms of whether or not certain type of activity is falling within essentially the interest of certain regulators. And what we're seeing the most where we're seeing the most enforcement activity has really been the activities of securities regulators in the cryptocurrency space. Going as recently as last week, where there were 2 decisions rendered in respect of foreign platforms operating in Canada. Quadriga is a well-known example, which you may have read about in the media. That is a former cryptocurrency exchange where the founder died unexpectedly, and on closer review by securities regulators turned out to be widespread fraud. And so that's really in some way given some of the direction on securities regulators to really focus and try to capture by way of enforcement where there's bad activity. FINTRAC, the anti-money laundering regulator, has been also increasingly focused on enforcement. There was a prior decision that resulted in FINTRAC overhauling its administrative monetary penalty regime, and that's been done. And so since then, it's been fairly active. Other areas, not seeing a ton of enforcement yet, but as we see more and more players in, say, the lending space, it may be that there is an increased focus going forward. And then banks in general, when we're looking at this space, they tend to be the essential relationship for a lot of fintech entities, either as a partner or provider of certain types of services and infrastructure. And as a result, often banks informally act as gatekeepers to some extent, and will look for a certain level of compliance on various regulatory requirements from fintechs that they work with. So certainly seeing some indirect type regulation and enforcement coming through fintech entities wishing to maintain relationships with their key bank partners. Turning to the next slide, I think that may be it. So I think in summary, certainly a lot going on in Canada on the fintech side, and interesting in terms of regulation. As we can see, it's a bit of a hodgepodge, which is similar to other jurisdictions, but certainly there are some Canadian quirks to how fintech is regulated in Canada. So coming up now, we've got a 5-minute break, and certainly don't want to stand in between your break and yourselves. So want to say thank you, and we'll see you shortly.
Well, welcome back, everyone. I hope you had a great break. It was short, but we do have some excellent speakers coming up for you now. So we're moving from fintech to cybertech, and we're lucky to have Charles Morgan here with us. He's our national co-leader of the Cyber Data Group based out of Montreal, and he's a former president of the International Technology Lawyers Association. Charles practices a whole bunch of different areas in this space involving cybersecurity, privacy, data governance. He's a go-to for us and on a very important area of the law. So I'll just turn it right over to you, Charles, and take it away. Thanks for joining us.
Thank you, Tim. So the conference today is, the cross-border theme runs large, and there couldn't be a better theme to lead us into the topic that I'm about to describe, which is privacy, cybersecurity, Quebec's Bill 64, what you need to know. And one of the reasons I say that is that one of the sources that led to the adoption of Bill 64 was actually the European GDPR, the General Data Protection Regulation. And under GDPR, which has become to a certain extent the de facto international standard for sort of high watermark privacy and data protection norms, one of the principles of that law is that personal data about EU data subjects can't be transferred outside of the EU unless it's transferred to a jurisdiction that's put in place adequate data protection measures. And, or you fall into a regime of exception and it gets a little bit more complicated, like US Privacy Shield and things like that. But Canada historically has been deemed by the Europeans to have an adequate data protection regime. And that facilitated the transfer of data from Europe to Canada and vice versa. But when the Europeans adopted GDPR, it introduced a whole new standard, and it was widely viewed that unless Canada amended its privacy laws, we would no longer maintain our adequacy standard, favorable adequacy position the next time it came up for review. And so Quebec was the first jurisdiction in Canada to adopt legislation that was designed to ensure that our privacy laws in Quebec were of a similar standard to the standard that you find in Europe, and that we would be able to maintain a favorable adequacy decision. Many of you on the call will know that the federal government has now just issued Bill C-27, which would do for the federal legislation exactly what Quebec has just done for the Quebec legislation. And what it means is a fundamental overhaul of privacy legislation in Canada. It means we are seeing European-style sanctions for data protection violations. And what it ultimately means, it's a whole new risk profile. The world has changed. Whereas before, privacy might have been a nice to have, a reputational issue, trying to do right by your customers, but it wasn't a major material compliance element when organized looked at their issues of enterprise-wide risk. Cybersecurity drew people's attention, but less so the privacy side. Now it's top of mind for everybody. So let me walk you through some of the most important elements of Bill 64, which is now law. So it's Law 25. And then I'll touch on what we can expect to see federally with Bill C-27. And I always start, just because it captures everybody's attention, with the new sanctions. So before, in Quebec, and Canada generally, it was largely a name and shame regime. If you didn't follow the law in the realm of privacy, well, you might get an unfavorable decision that was published on the commissioner's website. There might be an article in the newspaper. Certainly, worst case would be if there were a cybersecurity incident that it could lead to a class action. But there weren't really administrative monetary penalties of note. That has changed completely. And so there are administrative monetary penalties now of a maximum of $10 million or 2% of worldwide turnover for some violations, and up to $25 million or 4% of worldwide turnover for other kinds of violations under the law. Those penalties, even those penalties, it can be doubled in the case of a subsequent offense. So 4% of worldwide turnover for some companies, we're talking potentially billions of dollars in sanction. And of course that changes completely the risk profile of compliance efforts. Next slide. So the law has been adopted. Bill 64, as I say, is now on the books. It's Law 25. It was adopted received in Quebec Royal Assent on September 22nd, 2021. It's going to come into force over the next 3 years, starting this September. Some of the provisions, the majority of the provisions come into force September of next year. And then one of the provisions, the right to portability, comes into force September 22nd, 2024. What's coming on board soon, this September, are the provisions that related to the appointment of essentially a chief privacy officer, somebody who is in charge of protecting personal information. And that role by default goes to the person who has the highest level of authority in the organization. So it could be your CEO, for instance. By default, that's the person who will hold that role as of this September, unless the CEO were then to delegate that role to a chief privacy officer or to a privacy office. The second thing that comes online this September are the provisions related to the requirement to maintain a security incident log. So you have to keep a log of every single security incident that occurs. A confidentiality incident is what it's called under the law. And under certain circumstances, if you experience a security incident that results in a risk of serious injury to individuals, well, then you have to report that. There's mandatory statutory breach notification obligations that come in play. And those obligations, these ones that managed in September, they're manageable for most Canadian companies that have been working to be compliant with PIPEDA, the federal legislation up until now, because there's similar obligations that are already on the books. There's nuances that differentiate them, but they're similar. So many companies are in reasonably good shape already to be compliant with the obligations that come into effect this September. That is not the case for the obligations that come into effect September 22nd, 2023, in 1 year's time. These are the provisions that, and I'll drill down on some of them, that are the net new provisions that are inspired, as I say, largely by GDPR, and that are going to have an impact on how you manage your information governance. So there are governance issues that come into play. There's privacy by design issues that come into play that may have an impact on how you design your products and services. There's requirements that products and services that have privacy settings be by default set at the most privacy friendly level of availability. There's transparency obligations that are going to force virtually every company to not only to redo their or update the privacy policy, but redo how they manage consents. And then there are a range of provisions that are designed to get people to manage risk more effectively. And so related to data. And so from a data governance perspective, they will require companies, and I'll get to this in a moment, to implement privacy impact assessments, to do adequacy assessments when they're transferring data across border for processing. And these kinds of things, and there are also some provisions that relate to automated decision-making. So if you're involved in you have technology that allows for an automated assessment as to whether somebody is should be eligible for a credit application, that sort of thing. That will also be subject to brand new requirements. And this takes time. And what we're seeing is that really companies have to start now in the process preparing for their compliance in September 2023. And we've been helping our clients. We've been working with dozens and dozens, 50 or 60 different companies at the same time, at working through a 4-phase stage where we start with the current state analysis, we do a gap analysis, we work with our clients to develop a roadmap for compliance, and then implementation. And those 4 phases really have to start now if you're going to be ready for it in September 2023. Next slide, please. So I'm not going to go through all the details because these are large and there's a lot in there, but we have a lot of materials that are available through our website, and I'd be happy to take questions or answer to questions. But let me focus on a couple of sort of net new items that are, I think, particularly important and relevant to this cross-border theme for this conference. And the first is the requirement to conduct privacy impact assessments. And there are two different scenarios where the privacy impact assessment has to be conducted. The first is where an enterprise is either acquiring a net new information system that will be used to process personal information, or is involved in a material upgrade of an existing IT system that processes personal information. Before acquiring or updating the system, an entity has to implement a privacy impact assessment on the design and implementation for that system. So you have to look at things like security risks, privacy risks. Is it designed in a way that will facilitate the management of consents that you'll have to manage? Is it designed in a way that will facilitate the data portability requirements that you're going to have to meet, or the access and rectification obligations that you're going to have to meet? Because there are a whole set of new individual rights. In other words, your customers are going to have a lot more control over their data, and you have to make sure that your IT systems are designed in a way that will facilitate that, and designed in a way that will protect them against all the various forms of unauthorized access, use, or disclosure. So that's scenario number one. Scenario number two, and again, particularly relevant for this context on cross-border transactions or cross-border efforts, is that a privacy impact assessment must be conducted when communicating personal information outside Quebec. And you heard that right. It has to be conducted when personal information is transferred or communicated outside Quebec, which means that it's not even it's not just limited to scenarios where it's transferred outside of the country, outside of Canada. A Quebec to Ontario transfer would also qualify or be subject to this provision. And what Section 17 of Law 25, Bill 64 says is that before communicating the personal information outside of Quebec, a person carrying on, your chief privacy officer, or the person who's been delegated to conduct this effort by the chief privacy officer, has to conduct a privacy impact assessment that takes into account the sensitivity of the information that's being transferred, the purposes for which it'll be used, the protection measures, including contractual ones that would apply to it, and the legal framework applicable in the state in which the information would be communicated. So that last point is that you have to actually take a look at, in a sense, it's a private adequacy assessment, whereas in Europe, state actors assess the adequacy of privacy protections in various jurisdictions around the world. In Quebec, that role is being placed on the enterprise, which is an astonishing thing. And of course, not many enterprises are currently equipped to assess the adequacy. So they have to assess those frameworks against recognized personal information protection principles, and we'll have to get a clear sense of what those principles will be and how you can effectively assess that adequacy. And the key thing is that when you do after you've conducted this privacy impact assessment, before you transfer the data, you then have to put in place a written contract, a written agreement with the data processor that will serve to minimize any of these risks that you have identified in the privacy impact assessment. And the key there is that you're not prevented from transferring the data for processing outside the country or outside the province, but you do have to put in place contractual measures that will mitigate the risks that you've identified. Next slide. And so what's the content of those, the contract in question? Well, here you get a bit of a sense of it. Anytime you're dealing with a data processor, there aren't, Quebec doesn't impose standard contractual clauses like they have in Europe, but they do indicate what the contract must contain. Among other things, it's the measures, the mandatory, or in other words, the service provider who's performing the contract must take to protect the confidential personal information communicated. It must state that the information that's being sent for processing can only be used for performing the mandate or the service. In other words, they can't use it for their own purposes. They must only use it to perform the service, and ensure that the service provider does not keep the information after the expiry of the mandate. Next slide. So, as I say, the landscape is changing, borders are thickening, and complying with privacy law is getting more and more complex. It's not just Quebec that has completely gone off the deep end and gone its own way. It's a precursor to what we could expect to see across Canada more generally. And we know that because the federal government has just issued Bill C-27. It's not law yet. It was introduced into Parliament June 16, 2022. But it's a legislative initiative that is getting a lot of support from other actors across the political spectrum. So it is expected to pass. Bill C-27 introduces not only a complete overhaul of PIPEDA, in other words, our federal privacy law will now become the consumer protection, anyway, CPPA acronym, I've slipped my mind. In any event, we have the CPPA will introduce the same kind of fines of up to $25 million and 5% of an organization's gross global revenue. It will allow for cross-border data transfers, but whenever there are transfers by a company to a service provider outside the country, that the organization will have to make sure that the service providers provide an equivalent level of protection to the personal data that's being transferred. So I won't get into the details there. The Bill C-27, by the way, also introduced an entirely new act that would, if adopted, regulate artificial intelligence systems and high impact artificial intelligence systems. And that's a whole new realm of regulatory exploration that we're going to unpack and understand over the coming months. But the key is to understand that the privacy landscape in Canada is in the process of being fundamentally amended. The risk profile has been altered. And the time is now to make sure that you have begun the process to make sure that you will be compliant with the Canadian requirements as they come on board over the next 2 and 3 years. Thank you.
Thank you very much, Charles. I'm still reeling from your initial statement about the fines, and then you ended with the fines under the federal statute as it comes. So yeah, it's something to be definitely mindful of when you're looking at $25 million or 5% of revenue, I think is what you said. So I don't want to think about it anymore today. So we're going to move on to Martha Harrison. So thanks, Charles. Really appreciate it. Martha is a partner in our International Trade and Investment Law Group. She's also involved in the Retail and Consumer Markets Group and Advertising and Marketing Practice. Involved in a lot here at the firm, life of the firm as well. In international trade, she looks after things like customs and anti-dumping and foreign investment and import-export controls in a whole host of industries that the firm engages with clients in oil and gas, retail, mining, you name it. So I'll just stop now and let Martha take it away on supply chain, customs, and trade. Thanks for joining us, Martha. Really appreciate it.
Thanks, Tim. Appreciate being here. As Tim mentioned, I'm a partner in the International Trade and Investment team, and I have an additional focus on product regulatory law. And so in that capacity, I and the rest of our team here in the trade group advise regularly on cross-border initiatives involving everything from the transfer of goods and technologies, cross-border investments, and we do support our clients very actively in compliance and risk assessments in connection with cross-border activities. First slide, please. So I thought I would start by talking a little bit about the current drivers that we're seeing in supply chain management. Supply chain management actually encompasses a whole host of different legal regimes that our team deals with on a regular basis. And perhaps not surprisingly, as a result of the pandemic largely, we really did start to focus our strategic advice to clients around supply chain management because of, as we well know, the challenges involved in the import of export of goods throughout the pandemic in particular. And current drivers now are particularly interesting to review as they relate to ESG, so environmental, social, and governance. Those, the ESG matter is firmly tied to trade and regulatory issues, and those also impact directly on supply chain and investment flows. These can include issues such as diversification of supply chain partners, both from a people perspective, looking to include more diversity and inclusion in the supply chain, as well as from, say, a commercial perspective, looking at alternative sources of supply, ensuring that you're not overly reliant on one or two sources of supply, and looking around different jurisdictions that you may not have otherwise considered. We continue to work with clients as they address supply chain crunch because it has not completely remedied itself, especially in a few areas. The first being what I would call logistics disruption. And so the disruptions that stemmed from COVID-19, the COVID-19 pandemic, continue to impact both businesses and consumers as the flow of goods into key markets such as North America and Europe, as well as Southeast Asia and India, are restricted by continued shutdowns and overlapping shutdowns, either as they exist in ports or as they exist in certain manufacturing hubs, particularly in China and South Korea. And these major logistics disruptions have caused ripple effect across global supply chains and ultimately have caused goods to pile up in storage. Those impact their ships on their way to ports through diversion or being slowed down as they enter into major transport hubs. And of course, they also impact strategic inventory assessments that our clients have had to consider over the course of the pandemic. And so we have seen this trend improve slightly, but we continue to see a number of logistics stressors that our clients are dealing with. And we support the assessment of the commercial and trade viability of changing or altering logistics plans. And in that capacity, we work very closely with our transportation group, and we've been able to support clients in navigating last-minute urgent supply chain transaction changes. And a good example is the major logistics issues that were caused by the BC floods several months ago, where product being shipped cross country actually had to exit Canada, go through the United States, and back up into the British Columbia, Vancouver area. And so those are circumstances where we work very closely with regulators to ensure that the trade supply and compliance customs compliance requirements can be either softened or stretched in order to accommodate these urgent situations. The second area that we have been supporting our clients through in respect of supply chain relates to production delays. Of course, production delays during COVID-19 were headline news. There was a lot of ink spoiled around how Canadian importers, retailers, distributors can ensure that they have sufficient product to sell onto the market. And now what we're seeing is there's still an existence of a limited supply for key commodities and logistical capacity, leading to consumers often experiencing empty shelves in certain areas of the market, longer purchase times or longer wait times for goods to be imported, particularly if you're doing online purchasing, and also sometimes an increase in pricing. So in this sense, where we have supported clients is really around assisting them in reviewing their inventory management contractual arrangements. And that is a really good indicator of how our team is sort of providing the full suite of services in supply chain management. We've worked with accounting firms as well as our clients in the private sector to support new technological changes to inventory management. And the days, I would say, of sort of buffering inconsistent supply with excessive inventory at the lowest purchasing cost are quickly becoming sort of a relic of the past. And now manufacturers are evaluating risk first as a key decision point in their supply chain development. There are also additional production chain compliance measures that have been at the top of our clients' minds. And for example, we know that China, obviously as a production hub, can be a key source of supply for many Canadian clients. And there have been some developments over the course, over the course of the pandemic as well, where there are restrictions and now prohibitions against sourcing product from certain regions, certain individuals, certain entities in the region, in certain regions of China, largely linked to the association with gross human rights violations in the region of Xinjiang. And so there is a compliance obligation to examine due diligence practices for businesses involved in transacting with China, and to ensure that adequate information is collected about our clients' counterparts and enable a proper risk assessment to be made before making commitments. And the third area where we've been providing support to clients in respect of supply chain management is really around over-reliance on a limited number of third parties. And so what this means effectively is that, a Canadian entity will have all of its eggs in one basket as it relates to sources of supply or contractual arrangements for the supply of goods or services. And I would say, despite the inherent risk associated with focusing on sort of one major trading partner, many businesses have that as their strategy because they develop strong relationships with one major supplier or one major customer or export market and or one major supply chain partner. And this is particularly the case, I would say, for Canadian subsidiaries who rely heavily and sometimes even wholly on part of a parent company to provide them with goods, services, and to be their active and sometimes only source of supply. And commercial consequences have been quite acute in this particular area. Trying to exit from a source contract is particularly tricky if it's an intercompany contract. Trying to propose alternative remedies pursuant to a contract where you're exiting a purchase agreement that might be unexpected, those have been really challenging areas for our clients. And the trade team has been advising quite heavily on supporting Canadian companies expand their supply chain to consider sources of supply from some jurisdictions that they may not have otherwise considered. And we can help them in that sense identify efficiencies. So for example, a number of real life examples where we have identified certain jurisdictions with which Canada has a trade agreement in order for an importer to bring in goods on a duty-free basis if they satisfy the rules of origin of the trade agreement. And we've had a number of clients switch from a focus only on the Chinese area for production and move over to, for example, acquiring new partners in Europe to take advantage of the free trade agreement that we have with the European Union. A more diversified supply chain will actually increase the strength in the supply chain, decrease risk, And usually it actually leads to increased profits. And so there have been a couple of studies in the last 6 months that have indicated that an annual supply chain review will lead to often an increase in profits as between 4 and sometimes up to 12% on an annual year-over-year basis, particularly for obviously importers who are engaged in the cross-border selling and purchasing of goods. There have been a series of new legal obligations tied to trade compliance. And so while we talk about supply chain, we're really talking about sort of on the ground commercial partnerships with our clients. But it's important to note that there are also legal developments that need to be considered when we're dealing with supply chain management. There have been, for example, there is a relatively new import ban, which expanded upon a prior ban that we had in place relating to goods that are made in whole or in part by way of forced or prison labor. And in July 2020, the Canadian customs tariff was amended as an agreement that we struck with United States and Mexico in the negotiations of the new NAFTA, the CRISMA. And this operates to prohibit the importation of goods that are produced wholly or in part by forced labor from any country, not just the United States or Mexico. And so that's an example of increased supply chain compliance that now has to be considered by Canadian entities. The CBSA has started to enforce this ban at the border, but actually the enforcement regime and the system has still been relatively opaque. The regime is meant to follow sort of the following structure where shipments contained in a good are suspected potentially of being produced in whole or in part by forced labor, and they're detained at the border by CBSA agents for inspection. And if in the judgment of the officer, the goods were produced by forced labor, the officer will take appropriate steps to classify under our customs tariff regime. And then the determination is made on a case-by-case basis as to whether to release the good, to seize the good, and that's where our team can support. The other piece to think about in terms of legal changes in the recent past in Canada relates to modern slavery laws. Our new modern slavery law it's making its way through the House readings, and essentially this law will apply to Canadian linked entities that produce, sell, or distribute goods anywhere in the world, imports goods, or controls an entity that performs these activities. And this also applies to wholesalers. So it doesn't apply to every Canadian entity, but it does apply to entities that fulfill certain criteria, for example, having a certain number of annual revenues, a certain number of employees, et cetera. And the major gist of the legislation is to require entities to report in on the actions that they've taken, on the internal plans that they've taken to prevent and reduce the risk that forced labor or child labor is being used in supply chains. And so it's a reporting obligation. And already our clients are getting ready to put together their reporting templates and to start to gather the data required in order to comply with these rules. Second slide, and I will go through this one quickly. I've talked a little bit about two regulators in particular. One is the CBSA. The CBSA is our border officials, and they enforce customs compliance. And so they look at the classification of goods, the valuation of goods, and the origin of goods. And they perform verifications to ensure that importers have properly accounted for them. There are random verifications and targeted verifications. And perhaps most importantly is at the moment our global affairs division, who is administering and creating the regime around economic sanctions. We'll switch to the last slide, please. Economic sanctions could have been the subject of this full supply chain review, but perhaps not surprisingly, we have been inundated with Russia sanctions questions. These are amendments to our Special Economic Measures Act under a particular regulation relating to Russia, and they are largely activity-based. And so it prohibits Canadians in Canada and Canadians abroad from participating in certain dealings with individuals or entities listed in these sanctions. Violations of sanctions carry with them significant penalties and enforcement. And this has been particularly important for our Canadian financial institutions and our retailer sector, a lot of the M&A deal work that has been dramatically impacted by sanctions. And so we invite you to reach out to our team with any trade and sanctions questions. And I'll finally end with a plug for our firm supply chain solution that we have developed in the context of all of these new customs, trade, regulatory, and compliance obligations imposed on Canadian businesses. And the solution actually performs some verifications and audits to help clients understand where they may have risks, holes that need to be accounted for and reviewed. And we propose internal policies. We look for efficiencies in supply chain, and most importantly, we help clients identify the business risks, help them mitigate those risks in order to perform the business that they are seeking to carry out. So thanks very much.
Thanks a lot, Martha. Look, I've seen the supply chain audit in action, and in fact, even combined with the HR audit to deal with supply chain, human rights, and slavery and customs obligations. It's a great product. So thanks for bringing it up. Thanks for plugging it there at the end. I'm going to move on to competition and foreign investment update. Kate McNeice is here to join us. She's a partner in our competition, antitrust, and foreign investment group. I don't know if there's an acronym for that, so it's quite a mouthful. Interestingly, Kate is a member of the New York and Ontario bar, and as it relates to cross-border experience, second to none in terms of this topic and competition law. So looking forward to hearing what Ms. McNeice is going to tell us about competition, foreign investment. So take it away, Kate. Thank you.
Thanks, Tim, and thanks everyone for joining us today. As Tim said, I'm here to talk about the Competition Act and Investment Canada Act and provide some updates on some key trends and recent developments that we've seen involving those two statutes. So I'll start off with the Competition Act. For those who haven't run into it in the course of your practice, the Competition Act is a statute of general application, meaning it's industry agnostic, so can apply to anyone doing business in Canada. And generally speaking, it covers three categories of behavior. One is merger control or review of mergers. Certain mergers, as I'll discuss a little bit later, are subject to mandatory review and expiry of a 30-day waiting period prior to closing under the Competition Act. We also deal with civil conduct issues, which include things like abuse of a dominant position, price discrimination, deceptive marketing, and competitor collaborations that don't rise to the level of criminal cartels. And then thirdly, we do deal with cartels as well. So in case anyone is under investigation, our group is happy to help covering all aspects of competition law. And for the U.S. lawyers in the room, the Competition Act, as you'll imagine, generally covers similar topics to the Hart-Scott-Rodino Act, the Clayton Act, and Sherman Act in the United States. So the merger provisions of our Competition Act apply to transactions involving an operating business in Canada. The mandatory merger control provisions require transactions to exceed a certain financial threshold. So currently the target must have assets in Canada or revenues from sales in and from Canada of at least $93 million Canadian. So they are relatively high thresholds for the size of, relative to the size of the Canadian economy. There's also a party size threshold and a certain equity threshold that has to be exceeded before you fall within that mandatory notification category. It's important to note that this applies to any acquisition of a business operating in Canada. So whether it's a subsidiary of a company that's headquartered outside of Canada or a direct acquisition of a Canadian company. And that the merger control analysis is not the only thing we have to look at when we're considering a transaction. The Commissioner of Competition does have the power to review any acquisition, whether or not it requires this mandatory notification process within 1 year of closing. So when we're assessing the potential risks for a merger, we have to assess both the substantive risk, would this result in substantial prevention or lessening of competition, in addition to just deciding whether we have to put in a filing to the Commissioner of Competition. So, in recent years, we have observed a slight uptick in review and inquiries about non-notifiable mergers. The Bureau has certainly been putting resources into trying to increase its ability to identify mergers that may not require notification, but that they would be interested in taking a look at due to their potential impacts on relevant markets in Canada. And we have seen them challenge or reach a consensual and negotiated remedy in certain transactions that fall into that category, even where they don't necessarily impact broad swaths of the Canadian economy. Often we see them have an outsized impact in a small geographic area. So it's important to keep in mind when considering a transaction in Canada that the fact that it's a relatively small company or operates in a small area does not necessarily insulate you from transaction risk relating to competition issues. So as I'm sure many people have observed, we did see a decrease in the number of transactions that were reported to the Competition Bureau early in the COVID pandemic, but the most recently reported statistics do suggest that merger activity has increased somewhat. And we've seen enforcement statistics that are relatively consistent with what we saw in the years prior to the pandemic, with only a small number of transactions that required merger filings being subject to an in-depth complex review, and then about 40% of those transactions ultimately resulting in a remedy or abandonment of that transaction. One thing we have also seen recently in terms of merger review at the Bureau is taking a more litigious or aggressive stance, especially in cases where merging parties show an inclination to close their transaction despite a Bureau's ongoing review. So under the Act, as I mentioned, if your merger is notifiable, you need to wait out a waiting period and let that expire prior to closing. But the Bureau's review often can continue further than that statutory waiting period. So what we've observed is the Bureau's policy has shifted recently so that if you're in that situation where you are legally in a position to close but are still engaging with the Bureau about, for example, negotiating a consensual remedy, divestiture of assets that will resolve their issues under the Competition Act, and then you take steps to close, they may cut off consensual negotiations and start moving into litigation mode. So what we've seen is that in the last year or so since summer 2021, the Bureau has litigated 3 merger transactions, including Secure Tervita, which was unsuccessful in attempting to block closing, and more recently, the Rogers and Shaw merger. They've also negotiated a number of consent agreements that can be found on the Competition Tribunal's website. So the last point I'll make with respect to merger review is that we've seen, consistent with the Bureau's somewhat more aggressive stance and increased resources towards identifying non-notifiable mergers, we have seen an increase in companies or clients, including cross-border clients, considering Competition Act issues at the outset at the transaction planning or negotiation stage. So what we have seen is an increase in M&A agreements that include Competition Act closing conditions, in particular conditions that require substantive comfort from the Bureau prior to closing rather than just the expiry of the 30-day waiting period or the post second request waiting period, which is a bit of a difference in practice between Canada and the U.S. with respect to HSR notification. And we also see a lot of covenants setting out the efforts that a purchaser is required to make or not to make, as the case may be, in respect of remedies offered to resolve competition concerns. So if you can move to the next slide, the most recent developments in respect of the Competition Act are Competition Act amendments that came into force last Friday, so or last Thursday. So this is hot off the presses. The current government has expressed an interest in amending the Competition Act to ensure that the Bureau has the tools to protect competition in Canada, both through merger policy and through its other enforcement activities. And so, as I've said, this is a first tranche of amendments that were acted last week through the Budget Implementation Act. The Bureau has, and the government has, expressed an interest in additional changes to the Competition Act, but thus far the government has held some consultations on the issue, but has not definitively stated key priorities for further amendment under the Act or a timeline in which those amendments might be implemented. So I've listed a few of the key changes in the recent amendments that came into force last week on this slide. In the interest of time, I won't go through all of them, but I will flag one or two that I think are particularly interesting here. The first is the criminalization of wage fixing, so agreements to fix or decrease wages between competitors, and no poach agreements, so agreements between competitors not to recruit each other's employees. Historically, these types of activities have been added to Canada's criminal conspiracy provision in the Competition Act. Historically, that's been interpreted to only deal with sort of downstream activities, price fixing, allocation of markets in which competitors make sales. So this is really a first step towards applying that same criminal prohibition to upstream labor markets. And this really shows the influence that the U.S. policy is having in certain categories on the Competition Act, because this is a policy issue that's been quite live in the U.S. for the last couple of years. So, this is a relatively large change in terms of how we think about the Competition Act and how the criminal conspiracy provisions apply. It's unclear the extent to which the Bureau will be looking to enforce this provision or what activities they will consider to reach the threshold of being criminally prohibited. But it does not come into force until a year from the passage of the bill, so summer 2023. So we will certainly be providing additional guidance to our clients over the intervening year, and as the Bureau releases guidance itself as to how it intends to enforce these new provisions to highlight how companies can protect themselves from risk under these provisions. And we've also seen a significant increase in financial penalties relating to deceptive marketing issues and abuse of dominant position. So that now can incur penalties of up to 3% of worldwide turnover if the financial benefit can't be determined. So that's the previous caps were around $10 million or $15 million for those activities. So that's potentially a huge increase in the penalties that may be available for those things. And the last thing I'll mention is that amendments to the Act have included so-called drip pricing as an explicit form of misrepresentation. So that's where the Bureau, where a company, puts a price up front and then a number of additional fees and hidden costs are added to it so that the price is much higher when the customer goes to check out or complete a transaction. The Bureau has been successful in addressing this or getting penalties against companies who engage in this type of behavior under the more general deceptive marketing provisions of the Act, but they've now implemented explicit guidance that type of activity is not appropriate. So I'll move on to the Investment Canada Act, and I think my last minute here. So the Investment in Canada Act is our purpose-built foreign investment litigation. It applies to acquisitions of control of Canadian businesses by any non-Canadian, that includes U.S. companies. It's important to note that at least an administrative notification is required for any acquisition of control, even indirect acquisitions by U.S. companies of Canadian companies, of companies, headquartered outside of Canada that may have Canadian subsidiaries. So it's important to look sort of within the corporate structure and see if there is a Canadian operation to see if that type of administrative filing might be required. Certain investments, the administrative filing that is required is non-suspensory and can be filed post-closing. But there are certain investments that exceed financial thresholds that would require a pre-closing review and clearance by the Minister of Industry. And it's important to note in that respect that US investors are subject to a relatively high enterprise value threshold. So it's quite rare, well, depending on the size of the transaction, we see a smaller number of US-based investors subject to that provision, but the determination of whether an investor is US-based or a quote trade agreement investor subject to that higher threshold is based on the ultimate controlling parent and often the citizenship of the members of the board of directors. So it's important, and we're happy to advise on whether a given potential purchaser would be subject to that. The last point I'll make just before I run out of time is that we've been seeing increased scrutiny of investments under the national security provisions of the Act, starting at around the time of the COVID pandemic, but continuing as we see it now. There are particular concerns about Canadian targets that deal with personal information of Canadians, that deal with critical minerals, that deal with critical infrastructure or healthcare infrastructure in Canada, especially when there is a purchaser that is either controlled by a foreign state that the government may consider hostile, such as China or Russia, or has a significant minority interest in the purchaser from one of those potentially problematic countries. So it's important when you're considering a transaction dealing with a sensitive target in Canada to assess the potential purchaser side risk of a national security review. I think I've run out of time, so I'll stop there. But the Competition, Antitrust, and Foreign Investment Group, which I do agree, Tim, I think we need an acronym to make that a little bit less of a mouthful. We're always happy to answer any questions or advise on transactions or conduct issues under the act, under either of these acts.
Great. We'll come up with one, a catchy one. And I think actually in the fall, that the labor group and the competition group are going to put on a session dealing specifically with the wage fixing and the no poaching agreements, because it has that crossover, and it's incredibly important, and I think it's come as a surprise, at least to clients on the labor side, that they would actually regulate in that area. So we'll look forward to that, and we'll have our acronym ready at that point. So we've got some time to think about. So thanks a lot, Kate. Great presentation, all interesting, all very topical. So we're just going to move on to our last partner, Catherine Booth, and this is a topic close to home. Employment class actions in Canada, very topical, very significant, and Catherine is a lot of expertise to deal with this particular issue. She's a partner in a litigation group out of Vancouver. She practices both class actions and commercial litigation, and she's represented clients in employment, competition, price fixing, conspiracy, data breach, and product liability claims, all things that we've heard about already in these 2 hours. So Catherine, thanks for joining us, and it's yours to take us away. Thank you.
Thanks very much, Tim. It's always nice to end the presentation on a bit of a doomsday note with the scary class actions talk, but here we go. So I was hoping to chat today about some of the trends we're seeing both in class actions generally in Canada, and then specifically about employment-related class actions that are being brought, and which are the ones that are succeeding in Canada, and kind of looking forward, what can we expect. So the slide that's up right now is some statistics that we've compiled on class action filings in Canada generally, so not just employment class actions, but all of them in Canada over the last few years. So for the folks in the US or outside of Canada, just as a general matter, yes, we do have class actions in Canada. There's different class actions legislation in each province, and a different but similar regime across all the provinces. Unlike the US, there is no centralized system to manage parallel proceedings. So that means there can be more than one class proceeding filed at any given time in different provinces, and sometimes they're ongoing concurrently, which makes it always a bit of a fun challenge. Like very much in the US, the main battleground for Canada on class actions is usually certification. Will the case get certified as a class proceeding, or will the court say, no, it needs to go ahead only as an individual claim? And common issues trials are relatively rare still in Canada. At certification, similar to the US again, the main questions often come down to, are there common issues to be decided, and is a class action the preferable procedure for determining the claims? One of the main differences from the US and Canada is that, except for Ontario, there's no predominance requirement. So the common issues in Canada don't necessarily need to predominate over the individual ones. And what that really means is it's a bit easier to get a case certified here in Canada than it is in the US. And another key difference from the US is there's often no jury trials for common issues trials. And then the second class action certification question is preferable procedure. So is the class action the preferable procedure for determining the claim? So in terms of overall trends, we've definitely seen an increase in class action filings in Canada over the last few years. What this chart is showing you as well is there's a shift in filings from east to west. So Ontario and Quebec used to be the most active class action jurisdictions in Canada. Quebec still remains very active, as does Ontario, but we've seen a very big uptick in activity in British Columbia and a big shift in new filings out west. I think there's probably a few reasons for that. One of the main ones is likely to be the new class actions proceeding legislation that was enacted in Ontario in 2020. And that imposed some more plaintiff or defense-friendly and less plaintiff-friendly requirements, leaving BC as a bit more of a preferable location or venue for plaintiffs. And BC is also a no-cost regime. So there's a few factors that may be indicating the shift out west. But nonetheless, class actions overall on the rise in Canada, and some interesting trends. Next slide, please. So in terms of employment class actions specifically, what types of class actions are being brought in Canada, and in what circumstances are they proceeding? Generally, we're seeing a mixed bag of success for plaintiffs. Courts are not certifying all employment class actions. The claims that are more likely to succeed are the ones that focused on common policies and procedures of an employer, and they are less likely to succeed and pass the bar for certification if the claim is going to require a lot of individual assessment of the worker's circumstances. So those are the claims that are less likely to succeed. The other trend that I think we're starting to see is, courts are showing a willingness to want to allow employment-based class actions to go ahead as class proceedings. And so we've seen things like courts not enforcing arbitration clauses that they find to be unconscionable, and therefore allowing a class action to go ahead. The federal court recognizing the possibility of a tort of systemic negligence for harassment in the workplace, which other courts in Canada had previously found didn't exist, or shouldn't be allowed to go ahead if there's a contract. We've had findings most recently from the BC Court of Appeal that human rights tribunals or other internal avenues of redress for harassment type claims are not viable means of dealing with claims, and they're not preferable, and therefore the class action is the better regime. So that's not all of the cases by any means, but we are seeing a willingness on the part of courts to want to allow these cases to go ahead. So in terms of the categories of claims that we see most often in Canada, I think there's really three general buckets, and those are the ones listed on the slide that's up right now. The first one are denial of pay and benefits actions. So that's things where there's unpaid overtime or holiday pay, or there's been an error in how pay entitlements were calculated. Those have been part of the class actions right from the beginning, and they continue today. There was one just last week that was certified in Ontario, where their employer made an error in calculating long-term disability benefits, and that case was certified, and the court found that it was preferable to have the case go ahead as a class action. And so those continue to be kind of a perennial category of class actions that are going forward. The second bucket is worker classification actions. And those can take a few different forms. And it's really the debate about whether a worker is an employee and therefore entitled to the benefits and pay entitlements under various provincial employment standards acts, or whether they are an independent contractor and therefore just subject to whatever's provided for in their contract. And so that's a characterization question. Another form that it can take is whether a worker is properly classified as a manager and therefore potentially, for example, not entitled to overtime pay, or if they're really a non-managerial role in nature. And so there have been a couple of significant decisions in Canada in the last couple of years on this front, the most significant one being certification of the class proceeding against Uber on behalf of the drivers seeking essentially that they were improperly classified as independent contractors. And a court in Ontario allowed that case to be certified, and it's now going ahead. As well, in that same case, the Uber case, the court had originally found that there was an arbitration clause in the employment contract, and therefore the class proceeding shouldn't go ahead, it should be stayed. But the Supreme Court of Canada on appeal overturned that decision and essentially said the arbitration clause in the agreement was too onerous and essentially unfair. And therefore it was unconscionable to enforce it, and so found that it was invalid and allowed the driver's case to go ahead. So again, we see an example of a court stepping in there to show a willingness to allow the case to go ahead. The last bucket of class actions that we see most often and that are increasing, frankly, over the last few years are harassment and discrimination lawsuits. And those are often focused on the failure of an employer to prevent harassment or discrimination in the workplace. And you may think at first blush that those are things that may require some very individual determination, but we've seen plaintiffs get more sophisticated in how they're pleading these claims, and they're really focusing on common failures or policies of the employer to prevent workplace harassment. So just as an example, again, there was a recent case certified just a couple of months ago by the BC Court of Appeal. That was a case against WestJet by flight attendants alleging that WestJet had breached the terms of its employment contract by failing to implement a workplace program to combat harassment. So there were contractual provisions saying this is a harassment-free workplace and we will investigate, et cetera. And the claim was that they breached those contractual obligations. And so at the first level of court, the Chambers judge initially found that the case should not go ahead because really the claims were overlapping with what would be a human rights claim for harassment. And the judge there found that the Human Rights Tribunal was the better venue to deal with these sorts of complaints. But the BC Court of Appeal overturned that decision on appeal and found that these were really complaints or claims for breach of contract. And that wasn't identical to a claim for breach of human rights legislation. And so the case should be allowed to go forward on that basis. And the court also commented that there were some concerns about the ability of individuals to access the Human Rights Tribunal and get redress for those claims. So that's just one example. There were also certification of harassment and systemic negligence claims against the RCMP, for example. And so there are many recent examples. Next slide, please. So in terms of looking forward in my last minute, what can we expect? I think it's clear that employment-based claims are not going away in class actions in Canada. With the failures that plaintiffs have had in the past and also their successes, I think we're seeing the claims get more sophisticated and again, more focused on common practices, common policies, and common contracts to really make them more resistant to defense at certification stage and avoid the risk of having too many individual issues. So sometimes we're seeing narrow claims, but they're more strategically drafted. And then again, we're seeing a willingness of courts in some circumstances to allow those cases to go ahead where they think it's the most just means for these types of claims to be adjudicated. So employers, I think, will want to, from a class action risk management perspective, really pay attention to common workplace policies and procedures that they have in place, or the lack thereof, and any contractual obligations around those policies and procedures, to make sure that those are being followed and lived up to, and to help insulate against the risk of class action litigation in Canada. Thanks very much for having me.
Thank you very much, Catherine. Yeah, you ended it with a bang for sure. But these are our realities, and you know, this class action regime in some respects is an import from the U.S., which has been you know, difficult for employers because they really have to put, as you said, the practices and procedures in place from a compliance perspective on a regular basis to ensure that the you know, that the practices aren't open for you know, for these plaintiff side law firms to find some fault in the system and file these certifications on the strength of one representative plaintiff. So scary developments, but you know, there's things that employers can do to try and audit their practices and develop their procedures. So really appreciate that. We'll be interested to see how many additional class actions have been added to your chart next year. Hopefully not. Maybe it'll go down. So that wraps up our cross-border session. Folks, thank you all partners who have been panelists: Dave, Jennifer, Anna, Charles, Martha, Kate, Catherine. Thank you for giving your time. And thank you, most importantly, clients, friends of the firm, for joining us today. I hope it was useful. As Dave Leonard said at the front end of the session, there is a survey, a box somewhere on your screen. Takes 30 seconds to fill out. It's very helpful for us to design these programs in the future, if you can give some thought as to what you heard or what you want to hear. We have a whole bunch of cross-border resources that are available to you on our website. I think we provided in advance of the session a list of them for you as well in some email communication. Here's just a list of a few of them, but we do have a resources page on our website where you can find these cross-border specific documents, books, and there's blogs, of course, and web pages and white papers and all sorts of things. So have a look at those, and they're specific to different areas of the law. Just a final reminder, this program does qualify for CPD credits. So for those in British Columbia and Ontario and New York State and Quebec, up to 2 hours. For those who are registered under the HRPA or have a CPHR designation, also 2 hours of credits. You'll get an email, I think shortly, in the next couple of days, about those credits and how to apply for them. Specifically in New York, there's a code, and I'm told to just tell you what the code is. CB 062822. That's CB 062822 for those in New York State who want to use that to get these credits. So that concludes our program. Appreciate your attendance. Thanks for hanging on for the 2 hours. And if you have any questions about this, just pick up the phone or email your favorite McCarthy lawyer. I'm sure they'll help you with it. So thanks again, and have a great afternoon.